shit, they can never stop. Cause I've been really giving everything that I got. Cause I've been working on the plan.
Hey there, today we have some updates for you on the recent Meghan Markle American Riviera Orchard trademark applications. Now, we did a video not that long ago where we broke down the trademark applications and explained from the viewpoint of a trademark attorney what these applications meant and what the process was going to be like. Now, we previously told you that normally after you submit a trademark application, you can expect that it would probably be examined sometime within 8 to 10 months after submission. And then at that point, the trademark examiner would raise any issues they had with it or maybe ask for more information. And so that's what's happened now at this point. As you might recall, there are actually 3 separate applications that were submitted for American Riviera Orchard. There were 2 that were submitted for the name, one in March, and then there was a later one with more goods attached to it. And then there was a 3rd application for the logo. So now, at this point in the game, all of the applications have been examined by someone from the USPTO, and that person has issued what's called initial refusals on the applications. Now, if you have read any recent media articles about this at all, it sounds like total panic. Oh my God, all these marks are dead in the water. The business is done, kaput. That's really not what an initial refusal means. And definitely not necessarily, because at this point, if you were issued an initial refusal, you have a 3-month time period to respond to all the issues and sometimes objections that an examiner is raising within the applications. Now, as a trademark attorney, my job when clients come to me is normally to look at what they want to submit, look at the categories of goods, do a search to see if there's anything else concerning, and we try to avoid any type of initial refusals or major issues with the applications. Now, it doesn't mean that you can absolutely avoid these initial refusals. In fact, we get them not infrequently, and many times they're pretty minor in nature. It might be merely correcting something, it might be classifying the goods or services differently. The stuff that we want to watch out for are really initial refusals regarding confusion or stating that there's another mark out there that is likely to lead to a final refusal because the marks are too similar. Note that in all 3 of these applications, there is no such refusal regarding that. There's no likelihood of confusion refusals. So what does that mean? That really means that the remaining problems are likely things that can be fixed by the trademark attorneys. So what types of issues did they raise? Well, there's some pretty interesting ones that we'll do some screenshots and show you exactly what they are, what we're talking about here. Okay, the first one we're going to talk about is the application submitted for the logo back in March. So this was an application to try to protect the logo that is ARO in a stylized script form. Now, this initial refusal is very interesting in terms of what the USPTO says. So some of the issues with this mark include having to disclaim some descriptive wording, which you're going to see in the other ones as well, an amendment of the description, an amendment of the goods that were written in the application, maybe registering for additional classes because too many were jammed into one class and paying more fees, and a failure to verify the application. So those seem like a lot of issues, but most of them can be fairly easily overcome. So the biggest problem in this one is really that USPTO, from their perspective, American Riviera and Orchard might be descriptive. They could be descriptive from a geographical standpoint. Orchard is something that might not be able to be connected with certain goods and services. And so the trademark attorney is going to have to argue why those are not merely descriptive or why they're not geographically descriptive. But note, there were many, many classes of goods and services submitted with this application. In fact, I think that the office counts it up and it's 17. So there's only 2 classes that objection refers to, and it's usually the jams and it's the retail, because those could state, hey, these are where the goods originated, and that's why you can't trademark that, because it's just geographically descriptive of where these goods originated or where you're selling them. So all the other classes are okay as far as the geographically descriptive objection, which would be the one that's most concerning to overcome for sure. Next is an interesting one. This is the most interesting part, is the requirement to amend the mark description. So amend the mark description means that when a logo or a stylized drawing is submitted for registration, the attorney has to also, in words, describe what that is. So the description of this basically said ARO in a stylized font. The USPTO states that the letter O really doesn't appear in the mark. It says that it's in fact so not clearly visible or highly stylized that it's unrecognizable as a letter. So what USPTO is asking is that they amend the description of the drawing to basically state that it's just overlapping letters A and R, and that A has a stylized flower, and that they have decorative and looping lines. So that one's really interesting, especially if you want the ARO part to be protected. What USPTO is saying is they can't even see the O, and so they want the description of the mark amended to just reflect AR. How they're going to overcome that one, I'm not sure. It could be a bit concerning in that, are you giving up, rights to state that the O is part of that logo? I don't know. That one will be fun to see how they respond to that one. Next is then just clarifying some of the goods and services that are in there. For example, they state that something like cocktail napkins is too broad because it encompasses other things. Pans are too broad. Some of the cooking utensils are too broad. Soap dispensers. And so ultimately what they have to do is just rewrite how they've described the goods or services. USPTO makes that very helpful because they will actually put provided compliant descriptions in there that the attorney could adopt in their response. So that one's not really super hard to overcome either. And there's also many goods and services in there that you'll see from the screenshot that were accepted as written and don't have to be amended at all. So in all honesty, if you submit a trademark application with 17 classes of goods and services, it's highly unlikely that you wouldn't get this type of objection or refusal to any of them, right? So again, this is not really a bad thing. It doesn't mean the application's dead in the water. It just, this is how it has to get corrected by the trademark attorney. Next is that there were fees submitted for 17 classes of goods. As far as USPTO is concerned, based on the way that were described, it's really 19 classes of goods. So there's another like $750 due on this particular application to add more classes, goods or services. Now, another really interesting objection that they have raised here was a failure to verify the application. That means that when this application was submitted, nobody signed it. Now, when we submit trademark applications on behalf of clients, often if I have enough information from the client as the attorney, I am empowered to verify and sign that application on behalf of the client. And that's something that's routinely done. That would not be at all unusual. In this instance, it wasn't signed by anyone. So either the attorneys could have signed it, or they could have had the client, Markle, or whoever was authorized to sign on behalf of her entity, which is actually Mama Knows Best LLC. Somebody would have had to sign this application with a verified statement saying that to the best of their knowledge, everything in this application is true and correct. That was not done. So again, that's fixable, but kind of like a strange thing that wasn't done in the first place, right? Okay, so that is the status of the logo mark. So they're going to have 90 days to respond. It'll be interesting to see what the responses are, how they get around the geographically descriptive and the disclaimers, and ultimately what they're left with in the trademark applications. None of this is fatal at this point. They have an opportunity to correct these issues. Many of them are correctable and in fact are easily correctable, but there's a couple in there that are a little stickier. It'll definitely be interesting to see what happens. So hope you enjoyed this video. Thanks.
I'm a young boss, got me feeling like a rock. They can never match it, they can never stop. Cause I've been really giving everything that I got. Cause I've been working on a plan, on a plot. Over with the killers and we going to the top. We blowing up your city and you might get dropped. Cause we are never quitting, we are never giving up. So the enemies, I'm taking them apart. I'm a young boss, got me feeling like a rock.